Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, the Florida Bar tells me that I have to tell you that this podcast is not legal advice. But nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Do you have ME/CFS or fibromyalgia? Now, I've talked about this disease or these diseases in other episodes, but they're among the trickiest of illnesses to litigate because they're ambiguous, they're hard to diagnose, they're based on subjective complaints, and disability carriers, quite frankly, hate these types of claims. Today, I want to talk about three specific topics. Now, just because this episode is focused on ME/CFS or fibromyalgia doesn't mean that you should just stop listening, because these topics can relate to other disability claims. It doesn't matter if you have ME/CFS or fibromyalgia, MS, Parkinson's, you name it. These are the types of issues that arise in all disability claims. So first, I'm going to talk about meeting the elimination period in your long-term disability policy if you have ME/CFS or fibromyalgia. 2, the 8 reasons used by disability carriers to justify a claims denial of an ME/CFS or fibromyalgia disability insurance claim. And the you really have a psychiatric impairment and not a disability insurance claim based on your ME/CFS or fibromyalgia game that disability carriers play. Got it? All right, let's take a break for a moment before we get started.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at kvlaw.com today.
Welcome back to Winning Isn't Easy. Meeting the elimination period in your long-term disability policy if you have ME/CFS or fibromyalgia. A common feature of disability insurance policies or plans is the requirement that you satisfy what's called an elimination period before you become eligible for your disability benefits. You aren't paid benefits during this elimination period, but if you don't satisfy the elimination period, you won't get paid any benefits. In fact, your claim will be denied. It is among the first line of defenses for a disability carrier or a plan. What is an elimination period? The length of an elimination period and the nature of the disability can vary from policy to policy and plan to plan. That's why it's important that you should be reviewing your policy or plan closely. So you have to meet both the duration and the disability requirements during the elimination period. Now, some elimination periods can be as short as 2 weeks. Some can be as long as a year. During this elimination period, generally you have to be disabled, as that term is defined by your policy or plan. In some instances, that means you have to be totally disabled for the entire elimination period. In other instances, you can be partially disabled, and you have to know which it is and for how long before you stop work and apply for benefits. Because if you don't understand this and you don't meet the elimination period, you really can't correct it after the fact. So when you're beginning to have problems and you're thinking about going out of work, get the blasted policy and plan and read it. Understand what you have to show. If you have to show that you're totally disabled, you want to make sure your doctor's going to support a total disability elimination period for however long that might be. If it says that you can be residually disabled, then you need to make sure that your earnings fall below normally 80% of your pre-disability earnings. And there are some elimination policy provisions that say you have to be totally disabled for a period of time and then you can be residually disabled. Or you can be residually disabled and then you can be totally disabled so long as it occurs during the elimination period. It's a mishmash, and you got to understand what your particular policy or plan says. So let me give you an example of how this can go down. This is the case of Tranbarger versus Lincoln Life. It's a case out of Ohio. Tranbarger was an accounts receivable manager for David Feldman Worldwide, and she became disabled as a result of fibromyalgia. Her employer's disability policy had an unusually lengthy elimination period that required her to be totally disabled from performing each of the main duties of her occupation for 180 days within a 360-day period. All right, everybody's already starting to probably glaze over with these numbers, but they're going to be important. She applied for disability benefits and it was denied because her medical records didn't establish she was totally disabled during the elimination period. Lincoln reviewed her medical records, her physical therapy records. They took her statement. And while she may have experienced severe and disabling symptoms on some days, on other days she didn't. And that's consistent with the nature of fibromyalgia. So what happened was they actually got the calendar out and they looked at the days, they looked at the medical records, they tried to figure out whether or not she was consistently totally disabled. And of course they took her statement to nail down whatever it is they thought was going to be the basis of the denial. Ultimately, what happened was the court agreed based on their own review of the medical records, the physical therapy notes, and her statement. This was not a well-planned out disability claim. So what are the lessons to be learned? I think this case is instructive for a number of reasons. The lessons first learned are: 1, before you stop work and apply for your benefits, get a copy of your policy or plan and review it cover to cover. 2, understand how long the elimination period is and what you have to prove during the elimination period to establish your entitlement to benefits. Review your medical records to see if the nature of your symptoms and the physical findings confirm that you're in fact disabled during the elimination period. And if not, postpone the blasted decision to stop work and apply for benefits, and clean up your medical records and make sure that you are consulting with an experienced ERISA disability attorney. That attorney will help you develop the strategy to clean up those medical records, to prove that you're disabled as defined by the terms of the policy and plan during the elimination period, to make sure that all your I's are dotted, your T's are crossed, so that you're going to be submitting a winning application. Don't give the carrier a reason to deny the claim. Disability carriers are in the business of denying benefits, and basically Tranbarger gave them the reasons to deny the claim on a silver platter. You've got to understand the terms of the policy of the plan, the length of the elimination period, what you have to prove in terms of disability during that elimination period. Otherwise, you can lose before you get out of the gate. Don't be a Tranbarger. Consult with an experienced ERISA disability attorney. Got it? Let's take a break.